Appreciate your being on these, being an experienced agent, because it gives some depth, I think, with the new licensees that come on.
In my experience, I've used these for well and water testing and for agent disclosure. And otherwise, it typically means, NA on most other boxes.
Mm-hmm.
I'm wondering what other agents are doing and what KW wants us to include Addendum 8 is what the information I've received.
Yeah, good question.
Per transaction coordinator so that they have the contact information for the other side.
Right. It's basically, and I'll repeat this when we get started, basically the Addendum A is a consumer protection form. And obviously the GMAR is more so than the WRA, which is only 2 pages, but it is heavily legally a consumer protection form. So you can see my screen and you can see me?
Yes.
Carla? Okay.
Mm-hmm.
We'll wait a few minutes. A minute. Hi. Okay. Well, hello, everybody who's on already. I appreciate it. We're going to talk about the Addendum A today. And there's a lot packed into that form. And I think the idea is to really understand what's packed into it and whether you need to attach it or not. But as I was just mentioning, it's actually a result of many lawsuits, a lot of result of many legal opinions, and every time there's a new one, it gets added and revised to the Addendum A. So the Addendum A is a basic consumer protection form. And there's so many things that are in the Addendum A that you may need to consider when you want to attach it to your offer to purchase. I know many agents totally disregard it unless they have well water. When they added the agent identification on there because of TRID, more agents started using it because it did have the agent identification at the very end. But still, I think today we're just going to talk about what is all packed in. I'm going to hopefully not get too deep into each section because it could take us a long time. So I'd like to get through the whole document of Addendum A. And if you have more in-depth questions, put it in chat or just call me or text me later. If you're using or about to use an Addendum A and you still don't quite understand, please contact Steph or me when we can answer your questions specifically. So we've got a good group here, and I'm going to start by sharing the Addendum A. Okay, hopefully you can see my screen. Everybody all right on that? So let's just get right into it. Obviously the first 4 lines are identifying who the buyer is and the property. and make sure that you fill it out carefully with the buyer's full name. And then they're talking about how you fill this out. There were always some arguments about if it was an open box, it doesn't mean that it's included, but some people wanted to include it and didn't put anything in the box. They're just saying it's really fulfilling the contract if you put an NA in the box, if you are not going to apply it to your offer, and an X if you are going to. So that's what these lines talk about. And now here's the first option that a buyer can choose, attaching this addendum A to their offer to purchase. If the buyer wants the seller to pay closing cost credits, this is the spot where he puts an X and then the amount of the closing cost credit on there. It's a good idea to always check with the lender on what is allowed for a closing cost credit for your buyer. I think some people think it's just an open line and you can put in as much money as the buyer's going to ask the seller for, but there actually is, according to a buyer's lender, an amount, a maximum amount of closing cost credit that a buyer can ask for. So check with your lender. This is also the place to check if they want the home warranty program that's being offered. So it will be probably, if it's being offered with the listing, then you want to check the seller is going to pay and provide the home warranty. If you'd rather have ours be the one provided, you have to say that the seller will provide by the selling firm, the Keller Williams firm. But generally people just say they want the seller to pay for the home warranty from the seller's firm that they are supplying. And a buyer has been informed of the availability of a limited home warranty plan. This is important. And again, consumer protection, they want to make sure that you, the buyer's agent, did inform them that there is one available. There's been a question sometimes when one is available, a home warranty plan is available, it is not marked in the offer that the buyer wants it. And the ruling is that the offer prevails. So if the buyer did not check that they wanted it, they're not getting it, even though the seller was offering it. This is a good place to put in an association fee because there are a lot of places other than a condominium sometimes that have an association fee. So some subdivisions have them for single family homes, and this is a place to put it in if you're not writing a condo offer that already has a place for association fee. Now we're getting to I would say probably one of the most debated and important parts of this Addendum A. If your buyer wants any testing done except for radon, radon is now in the offer to purchase. They took it out of Addendum A and plopped that one inspection in the offer to purchase, leaving the rest of possible testing to be included here in Addendum A. So say your buyer has severe allergies or concerned about asbestos or concerned about all of the drain tile testing and everything. Anything that needs a test is basically anything that you need to take a sample of and send it into a lab to find out. So they put a caution here. The firm and its agents recommend buyers have the property tested and inspected for all conditions that buyer considers material to the transaction. Those caution lines are in bold print for a reason. Please stress it when you're talking to your buyer about this. So under this guideline, real estate agents may furnish a list of independent inspectors. Don't just give them the name of one inspector or one tester. Give yourself options so you're not blamed for the results. A party designated as responsible for obtaining an inspection test shall be solely responsible for determining the qualifications of the inspector tester. That's trying to get you off the hook, so you don't get sued if something goes wrong. In the event any inspection or test is ordered on behalf of the parties by a firm in the transaction, the parties agree to hold the firm harmless for any damages. You can see there are probably many lawsuits over this little thing, other than caused by the firm's negligence or intentional wrongdoing. This is important. Buyer may receive copies of a certain inspection, test, appraisal, or other reports prepared for other persons. Buyers should carefully review these points to determine the age of the report. Very important, can be really outdated. The purpose for which they were prepared, the standards of practice followed by the individual preparing the report. So what they're saying is you can ask for old inspections, you can ask for old reports that the seller may have, but take those with a grain of salt. They may not be currently relevant. It is recommended that the buyer have the property inspected by a personal inspector and other qualified independent inspectors. Okay, so now it comes to testing. Put an X here if your buyer wants a test of something other than radon. So, current written report from a qualified party. Listen to this carefully. The results of the following tests conducted pursuant to an applicable government or industry protocols and standards. They want you to identify the tests. Please, please, please don't just write in this line any tests recommended by the inspector. If you do put that, don't have that be the sole verbiage on this line. You are to literally list the test. And so most agents say, well, how do I know what tests are to be tested if we haven't had the inspection yet, if we don't know what's wrong? Generally, you look to your buyer and you say, what would bother you the most? You know, if asbestos is something that you are concerned about, we'll write asbestos in here. If lead-based paint has its own form, that's Addendum S. Radon, as I said, is an offer to purchase, but other tests that can go in here are supposed to be actually listed and not just say any test mentioned by the inspector. So it says, even again, insert tests to be performed like asbestos, mold, or other substances or conditions which may affect the health of the occupants or the value and structure of the property. So twice they're saying put the actual tests in and don't just say any test recommended by the inspector. And within blank days, 15 is good. You want the tests done at buyer's expense generally, and the testing shall be performed by a qualified independent third party. And then what are you going to give the seller the right to cure? Just like inspection contingency, say if mold is found, you are going to give the seller the right to cure that mold, or you will not. Now, the other main reason that people attach an addendum A to their offer to purchase is if there's a private well and or a septic, a private septic. If those two things, if you're working somewhere out in the country and they do have these active wells serving the property, this offer is contingent on the buyer receiving no later than blank written report. And this is where these are tricky. They want these to be current no earlier than 60 days before the closing. From a state certified or other qualified lab, which indicates that the well are supplying what is established as levels by the state regulating public water systems for safe human consumption to the following substances. So if you don't touch this, other than marking an X here and maybe 15 days in here, they're going to test. This was contingent on nitrates and arsenic. You can add other tests on there, and a lot of people will put nitrite or lead or pesticides, copper or radium, those can be added as additional tests in this well water contingency only if you write them in. Otherwise, it's just going to be on bacteria, nitrates, and arsenic. Be pre-warned that the arsenic test takes a while, and so you just can't do it at last minute sort of things. But it all has to be within 60 days prior to the date set for closing. Now, who is going to be responsible for obtaining these reports? The buyer usually gives that to the seller, including all costs, and agrees to promptly provide copies of those reports to the other party. All water samples, now this is critical. All water samples used for testing shall be taken by a licensed plumber or other qualified independent third parties. Back in the day, we agents used to have our little vial and go take our own samples and things. They don't want that anymore. You have to have a plumber do the samples. And then you can, again, with the water, you can give the seller right to cure or not. Basically, most things found in water like bacteria, nitrates, or arsenic can be cured quite easily, but you want to give the seller the right to cure them. They are easily, well, not easily. Bacteria is easy. They just put chlorine in the water. But there are others. If you want more information, if your buyer wants more information, click this link. Now, there are two different things here: well water and well system. The well system is the pump and the pressure tank. So if the property is served by an active well other than a community well, you can't put in an X here if it's a community well, like for a subdivision. That's under shared wells. So you're going to, this offer is contingent upon buyer receiving no later than 15 days prior to the closing a written report no later than 60 days. So again, it has to be 60 days before the closing, 15 days prior to the report. The buyer has to receive this. Indicates that the well and the pressure system conform to the code and in effect time they were installed and are not disapproved for current use. So again, a plumber will do this inspection, a licensed pump installer or a licensed well driller, and they will test the pump system, test the pressure, and to make sure that they conform to the standards. And you want to give seller basically responsible for getting this report, including all costs, and then your choice whether to give the seller the right to cure or not. And this is a little technical thing, but it's in bold. If the well is inspected, the well water contingency is automatically selected and included in this offer. So you can't just go in and put an X right here in the well system and leave well water blank. It automatically becomes included if you check line 43. Any questions about well water or septic, well system, excuse me, that we just routine? Those dates, make sure that the dates are no later than 60 days before closing and that they are within no later than 15 days prior to the closing. They're in that time frame so that the buyer knows that they're getting a very current report.
I did have a question real quick on that. So generally when the well water gets tested, do most buyers just want nitrate and arsenic, or would they typically know if they want to do every other test?
Generally, if they want to do all the other tests, they really don't know. They just say, well, if it's there, I want that all tested. They have to realize if they want that all tested, that can be expensive to the seller. The seller may not want to do that.
Okay.
The other reason that they will select more than just bacteria, nitrates, and arsenic is maybe they have a particular sensitivity or fear from what they read or heard in the municipality. Maybe they're close to a golf course, they want to know about pesticides, things like that.
Okay.
Okay. Now, there's a place for abandoned wells, and in many municipalities where water used to come from a well and then a community stepped up and did the whole water system, some of these abandoned wells are left behind, and sometimes they're used for sprinkling the lawns and things like that. So this section is, if there's an abandoned well on the property, seller shall, prior to closing, close the well at buyer's expense, provide the buyer with the documentation of closure in compliance with applicable codes, or provide buyer with the documentation evidencing that the well has been previously closed and compliant with the applicable codes in the effect. So you as the buyer's agent, these are some of your extra duties to do. I would check the municipality for your buyer to make sure if abandoned wells can still be open for watering the lawn and things like that, or is it mandatory in that municipality that they all be closed? If they can be left open, you want to cross this out. Otherwise, you leave it as it is, and that instructs the seller has to close that well. Under shared wells, if the well providing drinking water to the property is a private shared well, seller shall at seller's expense provide buyer with a copy of the shared well agreement, which provides standards for operation, maintenance, and use of the shared well for residential purposes no later than 15 days prior to closing. Unless this sentence is stricken, the amendment shall provide for a pro rata cost sharing for all parcels included in the agreement. If the agreement has not already been recorded, it shall be provided in recordable form. This is an important section. If you're going to leave it in, there are going to be requirements that you're going to have to do for your buyer about that agreement for a shared well. Now, a shared well can be in a subdivision, and if that's the case, all that has been taken care of. It's part of the declaration bylaws of a subdivision. If it is a private shared well, say between two neighbors, there should be an agreement. It should be then recorded, and that agreement should be in a recordable form. Based on the particular situation with this, make sure that you have that understood. Otherwise, you want to cross this out. So again, it's something, don't just leave these things blank. You've got to read them. You've got to understand them. But this is only if the well provides drinking water to the property is a private shared well. Now we get into sewage situations. So here's well water, and now we're into private sanitary sewage systems, or POUTS as they're called, private on-site wastewater treatment system. So POUTS is one of your acronyms that you should use on a daily basis from now on. If the property is served by a private sanitary system, this offers contingent upon buyer receiving no later than 15 days prior to closing, so it has to be a current, fresh inspection, a written report dated no earlier than so many days prior to the date set for closing, 60 if left blank, from a county code administrator, a licensed master plumber, a licensed master plumber restricted service, a licensed plumbing designer, a registered engineer, a certified POUTS inspector, a certified septage operator, certified soils tester, which indicates that the POUTS conforms to the code in effect when the system was installed and is not disapproved for current use. That's very important to read and to acknowledge with your buyer if you are buying something that has a private wastewater treatment system or a POUTS. Generally, the seller shall be responsible for getting this report, including all the costs other than pumping costs. The POUTS is to be pumped at the time of inspection at seller's expense, regardless of the strike on line 1. So even if you said the buyer is responsible for getting this report, the seller still has to pay for the pumping. And then you have the choice of whether you're going to give that seller right to cure or not. This caution, bold lines, different professionals may be needed to inspect different system components. Buyers aware that pouts are regulated by the state and county agencies. Additional inspection, testing, and ongoing maintenance may be required upon transfer of the property. Your buyer has to be fully aware of what it takes to have a pout system on their house. They're coming from a municipality sewage system. This is all going to be new to them, and your rights, your duties, or responsibilities as a buyer's agent is to inform them as much information as possible. If you don't know it, you get it. So to make sure that your buyer gets it. Any question about house? It's not a pleasant subject, and it's not a pleasant contingency to deal with. Okay, so now they're talking about the right to cure. What does it mean, or the right to cure, for either the water, the well system, and the private sanitary? So they want to define that specifically for Addendum A if you're giving right to cure. It means that shall be deemed satisfied unless the buyer, and this is buried in tiny little print, make sure you see it, within 5 days of each contingency selected above, testing, well water, well system, pouts, is the earlier of an actual receipt of the applicable testing, water, well system, sanitary system reports, or the deadline for delivery of these reports delivers to the earlier of the, a copy of the reports and a written notice identifying the defects to which the buyer objects. So the buyer within 5 days has to object to the buyer's actual receipt of the testing. So he has to have actual receipt, not his agent, but his actual receipt of the report, or the deadline for the delivery has arrived. He has then delivers to the seller a copy of the report, number one, and a written notice identifying the defects to which he objects, or the deadline of the delivery report and the seller was to provide were not delivered. Buyer delivers to seller a written notice to terminate. So if he didn't get the reports, this buyer can terminate with a written notice, or if the buyer decides to send a notice with the reports that he objects to it, notice of defect, or the date has come and gone. I can help you with these if you have a specific situation, ironing these all out, so can Steph. But make sure that when you are writing in the Addendum A and you are dealing with well water or sewage systems, pouts, that you understand what the ramifications are on right to cure. It's very similar to the inspection right to cure on filing the notice of defect and the report in order to either terminate or to give the seller the right to cure. So the same thing is in the inspection report. This offer shall be null and void if buyer makes a timely delivery of the notice of defects and the report, and seller does not have the right to cure, or seller has the right to cure but says he will not cure, or seller does not timely deliver the notice of election to cure in time. So if any of those three things happen, this offer is null and void, and then you can send a camera. Any questions on right to cure regarding water or pouts? All clear as mud?
Joan, it's Carla. Question for us, delivery of notice.
Yes.
So if there's some of these things that come up
Mhm.
and the buyer is like, hey, notice of defects, then you write all of this information in that document,
Mhm. Of what
get
they.
buyer and seller signature.
Right, right. Not, no, a notice only has your buyer's signature on it. So
Okay,
you're sending a notice with your buyer's signature on it that they object to whatever defect there is. And
okay,
then, just like in the inspection contingency, the seller has however many days that they put in there under each contingency to elect a cure, or to say they're not going to cure, or if they say nothing, the deal is dead.
okay,
But a notice is only signed by one party.
got it.
Buyers and, well, the other party will then send a notice back. They'll send their notice back. Okay. So the buyer sends a notice that he's got objections to defects, and then the seller sends a notice back saying what he's going to do. He's either going to cure it, he's not going to cure it, or he's just gone dark. Sanitary district sewer construction, buyers informed. Now this is where I'm talking about consumer protection. Buyers informed that the property may be located within an established sanitary district. Buyer may be subject to taxes, special assessments, and other charges for sewer planning or construction, user fees, and related costs. Buyer is encouraged to contact officials of the sanitary district to inquire about such costs. This is just awareness, especially for buyers who have not been in this sort of situation before. So it's gonna, if you are in a sewer district, sanitary sewer district, there will be fees and charges. Okay, now we come to another can be serious part of the Addendum A, and that's under financing commitment contingencies. Additional terms. The financing commitment contingency in the offer includes the following terms. Within 7 days, and a lot of agents don't realize this, they may add an Addendum A, but they may not have read this part, because this has come up in several times in conversation and phone calls I get it. But it says within 7 days of acceptance, buyers shall obtain a written confirmation from a financial institution that buyer has applied for financing. You've got to stay with your buyer to make sure that they are in a timely basis, and this timely means 7 days to apply. Seller may no earlier than 7 days after acceptance, so seller can give him 7 days, deliver a written request for that confirmation of application. So I've had many calls from, say, a listing agent saying, my seller is getting leery about my buyer. I don't think that they've applied for a loan yet, you know, and I don't have their earnest money. If it's been a week, the seller can now say that they want they deliver a written request wanting confirmation of application of loan. Buyer shall deliver written confirmation of application no later than 5 days after seller's delivery of written request. Or seller may, at seller's option, deliver this offer to be null and void. So the seller can kill the contract if he's not getting this written confirmation that he's applied in a timely basis. Buyer agrees to pay all costs, any and all costs of obtaining financing, including the cost of closing the mortgage transaction. And again, this is buyer awareness. There may be additional costs for the first year premiums for private mortgage insurance or property casualty or extended coverage, insurance coverage. Flood insurance may be added. Again, be aware, buyer, these things may be added to the cost of getting your loan. And this is another good point. A loan commitment is defined as a commitment from a financial institution authorized to do business in the state of Wisconsin by the Department of Financial, which does not include a condition regarding the sale of the property unless the offer is contingent on the closing of the property. So if you get the loan commitment from your buyer, but one of those conditions say they still have to get the proceeds out of selling their home, that is not considered a loan commitment. But you wouldn't send that over to the seller anyway, because your buyer would then not have that protection of not having a loan commitment. You cannot consider it a loan commitment if they have a house to sell, unless they put that in as a contingency in the offer. Buyer acknowledges buyer's obligation to have a total purchase price, including mortgage loan proceeds, available at the time of closing. Buyer is advised to determine when buyer's loan proceeds will be funded to ensure that the funds will be available for the time of closing. And then here's a notice in bold. The closing company may require parties to wire funds necessary for the completion of the transaction to the closing company's account. The parties acknowledge this requirement may result in additional costs to be paid by the buyer, otherwise agreed to in writing. Make sure that you are helping your buyer through wiring funds fraud, that they are always to reconfirm with a phone call any email or call that they get saying they need an address or a new phone number or whatever. Always verify any communication about wiring funds back, either to the agent, or to the loan institution. Now, anybody using an FHA, VA, or USDA mortgage, and if this offer is contingent on buyer getting any of these mortgages, the buyer agrees to execute an FHA, VA, or USDA amendment to the contract, which shall give the buyer the right to terminate the offer if the property fails to appraise for the purchase price. And remember, appraisal for these loans also includes in a limited list repairs or defects in the property. It's not just an appraisal of value. Seller also agrees to pay lender at the time of closing a tax service fee not to exceed. So if you're writing for a buyer and they are writing an FHA and you don't include an FHA, or you don't include this Addendum A, you may be missing out on a lot of important information that your buyer should read. And if they're getting a VA mortgage, you check that, and the seller agrees to pay the entire funding fee not to exceed blank of the mortgage you're at. Basically, you'd leave that zero. Funding fees may not be divided between parties. You can't say buyer will pay part of this and seller pay part of this. Buyer agrees to pay all other costs of securing financing. Most VA and FHA loans are no 100% down, no percent down. And you want to don't have them also paying the funding fee. So that's what's the benefit of those loans, that they don't have to outlay cash, including the funding fee. This is a little concerning thing that your buyers should be aware of, and there's a link there so they can talk about benefits with the VA loans. Mortgage wood destroying insect inspection. If this offer is contingent upon a buyer getting in a VA loan, properties in a county where inspection for wood destroying insect is required. There's debate and doubt whether termites are in the counties of Milwaukee and Ozaukee and Wisconsin, but I would double check on that. But we do also have other wood destroying insects like carpenter ants. The buyer shall be responsible for obtaining a report from the VA approved operator. Buyer may terminate this offer by delivering written notice within 7 days, revealing damage. Should buyer fail to notify seller by the deadline, buyer waives the right to terminate the offer. So it's a little bit of a little extra protection for the VA buyer. And again, here's awareness paragraph for your buyer. Area conditions. Properties are affected by existing and proposed conditions and services in the area surrounding the property. So they're just saying buyer acknowledges that they have understood this, seller Buyer has reviewed sellers and firms' representations regarding known conditions, has become familiar with the area surrounding the property, and has investigated future proposed developments, consulted with local municipal officials, including the assessor's office as needed, and is satisfied with the current proposed area conditions. Notice that that's saying buyer, and it's not putting all that responsibility on disclosure of the seller. Seller may know of these things. They may put that in their condition report that they're aware of these proposed developments and everything. But this paragraph says that it is also the buyer's responsibility to know the area, be familiar with the area, investigate future proposed developments, and you can certainly help them with that. But it doesn't exclude the buyer from having responsibilities in understanding the area. Under property conditions, excuse me, parties are aware that news media, other public information sources indicate that asbestos, mold, lead-based paint, lead in the drinking water, radium, radon gas, and other toxic substances and chemicals within a structure of soils and water supplies can cause serious health hazards. Unless otherwise disclosed in writing, seller represents to the best of seller's knowledge of the property that it does not contain any of these things. A number of communities report that elevated levels of radium may be present in the municipal water supply. Buyer agrees to obtain expert independent third-party inspections and tests to determine if any of the material. So here's to your question. If they read about, there's some areas in Western Milwaukee of high levels of radium, then that would be an area where they would definitely put that in as a requested test. Buyer must include contingencies in this offer for any inspections or tests which buyer shall have performed. And this is really critical to read, especially in what we've been going through. Past flooding, water leakage, excessive damages may result in excessive mold growth, which may present health risks. If there's any information or evidence of excessive moisture in the property, buyer is encouraged to consult with appropriate mold experts and to inspect and to test for unsafe mold levels. Buyer acknowledges that in purchasing the property, the buyer has relied on the buyer's independent inspection and analysis of the property and upon the statements, disclosures, and representations contained in this offer, in any seller's disclosure report, and in any other written statements provided by buyer. Buyer further acknowledges that neither seller nor any real estate agents involved in this transaction have made any representations concerning the property or the transaction other than those stated in the offer, incorporated into this offer by reference, or otherwise provided to the buyer in writing, nor has any real estate agent made any statement purporting to be based on personal knowledge unless the same is specifically set forth in this offer, incorporated in this offer, otherwise provided to the buyer in writing. Buyer agrees that buyer has not requested seller nor any real estate agent offered to verify the accuracy of any of sellers or other third-party statements, disclosures, representations contained in this offer unless the request is specifically set forth in this offer. What this paragraph is saying to you, the buyer's agent, as you're filling this out for your buyer client is, let's get this clear. This is what we know. This is what we have been provided. This is what your options are when we write this offer as to what you want to know going forward. What tests you want going forward, what inspections specifically do you want going forward? Because we are going to guide the seller to tell us everything he knows about this property by the way we write the offer. And it's important, and that's why the Addendum A is now 4 pages long. Including underground storage tanks and basement fuel tanks. If that's a concern, and if you're anywhere on the Lower East Side, of Milwaukee, this is a concern. If buyer has notice or knowledge of an underground storage tank or basement or above ground fuel tank on the property, or if one is discovered prior to closing, seller shall, prior to closing, delivered to buyer written confirmation that the tank, related components, and procedures relating to the upgrading and or closure are in full compliance with federal, state, and local regulations. Seller's written confirmation shall include a copy of an applicable contractor's closure report and any required Department of Agriculture, Trade, and Consumer Protection. It is the buyer's sole responsibility to re-register in his or her name any underground storage tanks remaining in use on the property after the close of sale, and to comply with the debt cap, the Wisconsin Administrative Code requirements. Now note, and this is a big note, especially if you're an agent that's been working for a long time, here's a change. Removal of most residential basement fuel oil tanks is not required under state law. Now, that's not underground storage tanks, that's basement fuel oil tanks. Okay. And now they're talking about comprehensively zoning and building restrictions, comprehensive plans, non-conforming property, and building permits. There's a lot to dish in this paragraph that actually are the topic of a lot of phone calls that I get. And if you use an addendum A in your contract, you may have missed something. Municipal zoning and building restrictions affect the use of the property, and comprehensive plans may affect the future use or value of the property by influencing future developments. Buyers informed that many properties, including those in shoreland areas, are considering legal non-conforming properties which no longer conform to current zoning due to changing building regulations, restrictions, and lot size requirements. This may affect the buyer's ability to build, rebuild, remodel, replace, enlarge, or use an existing structure. Buyer is encouraged to take necessary steps to obtain an endorsement or to modification of a buyer's homeowner's insurance for protection. Firms and agents are neither required to investigate nor to determine any financial consequence to the buyer for lack of required building permits or any zoning, building restrictions, comprehensive plans, or non-conforming property status. If this property is damaged, destroyed, the government community may in some cases restrict or prohibit the reconstruction without a zoning or use variance. Buyers advised to check with the applicable municipal authorities regarding existing zoning, shoreline zoning, building restrictions, possible comprehensive plans, and building permits. If these issues are material to the builder's decision to purchase, ding, it's an important phrase. Further, the buyer is informed that some municipalities may have inaccurate and inconsistent documents, which may include, but not limited to, pre-76 properties in the city of West Allis. Caution, buyer assumes all responsibility and liability to research, verify, and confirm any of this information. Very important, very cautionary tale for buyers and taking on the responsibility that they have. They can't dump this all as a responsibility of the seller, and the seller's not a right to non-disclosure. Information on promotional materials. Buyer understands that the information which is contained in the multiple listing service sheets and additional promotional materials is obtained from a number of different sources and has not been independently verified or confirmed by the various real estate firms and agents. If any particular measurement or data element is important or material to the buyer, buyer assumes all responsibilities and liability to research, verify. I hope you can hear me. There's a little construction going on behind my back. Buyer is informed that some municipalities may have inaccurate and inconsistent documentation, which may include, not limited to, pre-76 properties. Now, oh, excuse me, I skipped that. If any particular measurement or data element is important or material to the buyer, buyer assumes all responsibilities and liability to research. Same line that's in the caution above on line 154. Further, buyer affirmatively represents and confirms that as to any particular measurement or data element which was or is important or material to the buyer as an inducement for the purchase, buyer has independently confirmed and or verified the accuracy. Again, lawsuit, that was a lawsuit. That was maybe several lawsuits that caused that paragraph to go in there. These are all results of stuff that happened between buyers and sellers that went to a lawsuit that was, how do we correct this? And the lawyers say to the WRA, the GMAR, I think you need to add that to your documentation. So they're just saying, buyer, you cannot say because they said the room was 20 by 30 and it turns out the room is 18 by 25, that I'm going to sue the seller because I'm going to sue the firm and I'm going to sue the agent because those were off, those measurements were off. They can't do that anymore. But there were tries before that. Unless a current survey has been provided to the buyer, the location and size of easements, improvements, lot lines, and possible encroachments have not been verified, and the firm recommends that the buyer investigates these items by obtaining a current survey. We do not have a requirement from the seller to provide a survey unless you put it in your offer. If you put it in your offer, you might get a lot of pushback from the seller. But if these are important to you, if you're going to have a fence done, or if you need to know these things, the buyer is responsible to find out what the lot survey is by hiring their own surveyor. You can put it in your offer, but you can say that the buyer is responsible for the obtaining it and paying for it. Again, a little part about floodplains and wetlands. How is this sound coming across? Can you still hear me? Okay, thank you. Buyer is aware that the floodplain and wetland maps referred to in the offer lack detail, are difficult to interpret, and may not be accurate. Buyer, again, is encouraged to personally examine such maps or consult with appropriate government officials to verify their accuracy and applicability. So if there's a lawsuit, and you get into the court, the judge is going to say, buyer, what did you do to figure this out? Or buyer, what did you do to find out if there is floodplain in your backyard? That responsibility clearly says in Addendum A that the buyer is also bears that responsibility, or does require that responsibility. So now they get into the whole point about insurance provisions. And again, very important. That's why this Addendum A is very important to attach to your offers, whether you're writing single family or condominium offers, because there is so much packed in here. And a lot of it is stuff that sometimes they don't want to deal with. Sometimes agents don't want to deal with it. But it is important to understand the building materials and insurability. Understand the insurability of electric service. They're aware that the property has tube or aluminum wiring, or if a property's electrical service uses fuses or is less than 100 amps, lenders and homeowners insurance may require that the service be upgraded to no less than 100 amp service breakers service, and may require that any tube or aluminum wiring be replaced. It's right there. All of this is so important for your buyer to read and understand. And on flood insurance, buyer is aware that buyer's lender may require, in the future, will require buyer to purchase flood insurance in connection with the purchase of this property. Flood insurance is expensive. And this is something that really, if you're in anywhere near water, you don't even really have to see water to be in areas that can be affected by a flood. Make sure that those investigations are done and that finding out whether they absolutely need flood insurance or not. Those premiums are subject to change for reasons including to, but not limited, law changes which may result in substantial amounts as compared with premiums previously charged for flood insurance. We went through that about 5-6 years ago. Flood insurance premiums just went skyrocket. Buyer is encouraged to consult with one or more carriers of flood insurance for a better understanding of flood insurance coverage and costs. They're not putting that obligation on you, agents, but you need to direct them to talk to at least 2 insurance agents about flood insurance coverage and costs. Buyer acknowledges that the premiums are likely to be required to purchase such insurance and said premiums may increase in the future. Buyer is aware that premiums previously paid for flood insurance on this property may not be an accurate indication. So another bell, warning, siren, be aware, buyer. And you as a buyer's agent are responsible for making sure they understand this. I got a call about a week ago from one of you that says, what does rental property ordinance mean in Addendum A? And I went, what? I don't recall this being in here, but it is. And it's just saying, again, making the buyer aware, City of Milwaukee requires a registration form and a fee of residential rental properties, with some exceptions, within 15 days of conveyance. So if you're in the City of Milwaukee, there may be a registration form and a fee attached to the sale of this rental property within 15 days of it being sold. Buyer must file a registration and pay the fee within 15 days of closing. Seller must file a seller notification form within 15 days of the closing. City of West Allis requires a fee and a current property owner registration when the tax mailed to address is different than the property address. And then they give you a phone number to call for specific information. So if you're involved in a transaction in rental properties in the City of Milwaukee or in West Allis, I would learn more about this so that your buyer is well versed.
Would that have to be an active rental property?
No, it just says residential rental properties. And there are some exceptions, which that may be in your question to the phone call.
Okay.
City of Milwaukee requires the property owner to pay for the replacement of property owned portions of lead water service whenever the following occurs. This is a snake pit. A leak or failure has been discovered in the service, or when the publicly owned segment of the service line is replaced on a planned or emergency basis. The city offers special assessment financing if such circumstances exist, and properties within 1 to 4 dwellings may be eligible for a city cost share. Again, they give you links and phone numbers for more information to see if it specifically goes to your property. Other communities may have same or similar types of property owner obligations relating to lead water service lines. Buyer acknowledges that if material to the buyer's decision to purchase, buyer has reviewed known conditions and has investigated or consulted with local municipal offices. It's your responsibility as the buyer's agent to let the buyer know what his responsibilities are. It's not your responsibility to call and get all that information. Your responsibility is to let your buyer know he has these responsibilities. Okay. No later than closing, seller shall provide buyer with written verification of paid property taxes. That's taken care of with title. contemplated or other outstanding special assessments. Conflicting provisions, should any provision of this addendum be in conflict with the provision in the offer, this is important, or any other addenda to the offer, the provisions of this addendum shall prevail. So if there's any conflict with what you wrote in the offer to purchase, what's in here is what will prevail in the court. Buyer and seller advised this addendum contains provisions that may not be appropriate in all transactions. No representation is made that the provisions in this addendum are appropriate, adequate, or legally sufficient for any specific transaction. Buyer and seller are encouraged to consult with their own legal counsel regarding the provisions. All right, so I said there's a lot to pack into Addendum A, a lot to consider when you use it to attach to your offer, and this is how you attach it. So it is made part of the X, and if you're attaching any of these other addendums, lead-based paint, the Addendum O, the Addendum R, or any additional topics, name them and make the box. So you put what it is and the label on it. And they give you a real setup for a complete contingency. If you want to write a contingency, they give you a lot of lines for additional provisions. And then you must fill out the bottom identification of the buyer, the firm for the buyer and the firm for the seller. If you look in MLS, the name of, if you're the buyer's agent, all of the information for the buyer's information is right at the bottom of the data sheet in MLS. And then they have to be initialed by both parties to be effective. As I said, it's an important document. It's something that you must understand yourself before you lay it on the table for a buyer, because you want to be able to capsulize and then specifically address the provisions in this Addendum A that affect your offer. But as you can see, don't just add it, staple it on your offer and send it in without knowing what's in it. And I, as a manager for a long time and now compliance broker, I strongly recommend using the Addendum A on all of your transactions. Any questions about it?
Yeah. Question from when you are listing a property and you're seeing all of these different offers come in and they don't have Addendum A.
Right. And that's the risk that the buyer is taking. It's not necessarily the risk for the seller. But there are a lot of enforcements in this Addendum A that the seller no longer has, like under the financing and things like that, if the Addendum A is not attached. So say there's an enforcement in here that your seller wants, you could put that just individual provision in your counter.
Okay.
Instead of making them fill out the whole Addendum A. But
all right.
If I had competing offers, I would just have a tendency to favor offers with a full Addendum A over offers that did not. I've really come across a lot of agents who never use an Addendum A, and I'm appalled.
Well, I believe when they came out with the new offer to purchase, a lot of let go of Addendum A, unfortunately.
I think so. And as you can see, I mean, Addendum A used to be one sheet with some initials at the bottom. Well, the offer used to be 2 pages. But the as you can see, all of those provisions in here are directly a result of lawsuits. And they just keep adding it on. And I'm sure the next time they redo the Addendum A, it'll probably be 5 or 6 pages. So any other general questions that you have on this?
Yeah, just to kind of go on what Carla was asking. So it shows that the buyer has a lot of different responsibilities in the addendum A. Is that not applicable then if you don't include it?
Correct. Yeah,
So, yeah, because at least from a seller's standpoint, I mean, obviously you don't want many contingencies, so people would put an addendum A with no contingencies just to make a stronger offer, correct?
correct.
Okay,
Yeah, because it does add responsibility to the buyer.
makes
And-
sense.
And if it went to a courtroom, the judge would definitely pick that difference up.
Okay.
All right, well, any other questions about addendum A specifically, please reach out to staff or to me as it relates to your individual transactions, because I'm glad there were quite a few of you here that signed on today and shared this with us. So, not, have a good day. I hope
Thank
the
you.
weather improves one of these days.
Yeah, thank you so much.
Thank you.
Thank you.
Bye-bye.